Hello, everyone. My name is Jared Hinton. I'm a graduate student here at the University of Louisville. I'm here with Adrian Lauf and Michael Losavio. They're both professors in computer science and computer engineering. They will introduce themselves further when they begin to speak, but we're going to talk about the legal space of cybersecurity, more issues for research and practice.
Yes, hello, I'm Adrian Lauf, Assistant Professor of Computer Engineering and Computer Science here at the University of Louisville. Thank you, Jared, for the introduction. My colleague next to me is?
I'm Michael Losavio, Assistant Professor in the Department of Criminal Justice and an adjunct instructor here in the Department of Computer Engineering and Computer Science. And thank you all for joining us.
Introduction.
All right, so today we're talking about aspects of the legal space within cybersecurity as a discipline as it operates. So the idea is we want to help identify and comply with the legal restrictions that can put you in crossways with law enforcement. So the three criteria focusing on is cybersecurity research, security testing, and security implementation. Being able to anticipate those policy concerns in a cybersecurity regime and to integrate traditional criminal justice regime into cybersecurity as a paradigm for cybersecurity.
We're building on the excellent program that was done a couple of sessions ago by Paula DeWitt at Texas A&M. They create a foundation for this essential, if abrasive, relationship between the law and technology. We would like to note that this is not legal advice that you can sue us over, in part because we're not billing, but also because a number of these questions have not been answered. It's in part due to the provenance of some of our statutes relating to this kind of conduct, which are easily 30, 40 years old, and did not anticipate the sorts of problems that would arise with ubiquitous networking.
So if we go back in time a little bit, when the idea of cybersecurity first was launched, I mean, if you think about the fact that computing systems were first of all meant as tools that were to be used in business context, and malicious intent was not really something that was addressed or even thought about in the early days of computing, just because feasibility was an issue, networking was an issue, and malicious intent was just not something most designers thought of. If you look at that, cybersecurity and digital forensics were two completely different topics. Digital forensics mostly focusing on finding traditional aspects of crime that might have been present on a computer, and cybersecurity being a completely different field where we were focused on the initial aspects of what cybercrime was, before that was even really a word. What we're going to look at is how public safety starts to incorporate elements of cybersecurity. If you think about, we have an ingrained culture of looking both ways when you cross the street, and that's important because we don't like getting hit by cars. We have decided as a society that that is not advantageous to our survival, and that's a learned behavior. And so cybersecurity becomes an aspect of public safety. There are still, of course, sectors that cross out of the public safety perspective, and digital forensics still has elements that are public safety only and not completely related to cybersecurity, but they're beginning to merge. And as we begin to integrate smart city components, Internet of Things, and ubiquitous computing overall, the impact of cybersecurity in public safety becomes much more pronounced. Forensics almost becomes completely encompassed because it's hard to find an area where networking and pervasive computing does not dominate.
Okay. In relation to public security, we're currently working on a project called the Cybersecurity Workforce Education Project. And the idea is to bring public safety personnel, police officers, probation officers into cybersecurity. We're wanting to introduce the concept of cybersecurity to police, to public safety personnel, so that they may pursue cybersecurity careers in the future, or at least give them the knowledge to protect themselves, protect their devices, And we would like to continue the project to give this information to the community through the police, essentially giving our public safety officers the knowledge to also train our community in cybersecurity, little things to teach them to not do certain things on their devices, on the computers, to better enhance cybersecurity as a team effort.
All right, so what do we mean by cybersecurity versus public safety and public security? So on the traditional cybersecurity side, we're talking about, for instance, the ubiquitous Stallings text on computer security, where we're focused on intrusion and intrusion detection or prevention. First of all, prevention through passive methods, detection through active methods, and then recovery, and I would even say resilience, where you've been breached. How do you recover secure computing environments, or how do you mitigate their propagation and their effects if they're actually active in a system? Whereas,
looking at the way in which our criminal justice systems in the West work, you have essentially a similar kind of values and goals you wish to achieve. This from the Police Foundation in the UK, we look at trying to prevent crime, prevent the infraction. You look to pursue and bring justice to those who break the law, which serves both a justice interest, but also a deterrence and potentially incapacitation argument to provide for that protection. And then, again, we always want to keep the Queen's peace. We want to maintain an ordered arrangement where we have a relatively law-abiding system. You see those manifested in the United States federal statute on sentencing, 18 U.S.C. 3553, which looks at three primary goals: deterrence, convincing them not to do it, prevent them from doing it by the threat of punishment; incapacitation, those who simply can't change their bad habits will be put away in such a way that they cannot continue to reoffend; and for the lucky few, rehabilitation, those people who can realize the nature of their wrongdoing and change the ways to, in fact, make it better. And as we all know, there have been a number of notorious people in the computer intrusion area who then turned around and became fairly competent consultants on how to secure systems, as opposed to those that just kept doing it until they got locked away. So, this has been going on even since the dawn of these networks. Robert Morris and his issue where he designed the Unix propagation program that just got out of hand and terrified the public back in the late 80s. The Niedorf prosecution, whereas he was convicted and pled to certain offenses, his colleague, who was then prosecuted for interstate transportation of stolen property, had that prosecution sort of explode because no one really understood the facts of the technology as they applied to the algorithms of the law. It's all a matter of trying to understand and get a firm grasp of the duties, legal requirements, even our ethical obligations. And we teach a course here on law and ethics in computing here in the computer science department, which says, you know, your ethical sense can be an early warning sign of some problems. And the joke is we don't want anyone to have an inside view of cybersecurity and cybercrime because they may have thought they were doing the right thing, but that does not excuse where they might have conducted themselves as to violate the law. So accountability in cybersecurity research and practice. You know, we're just not immune, even again with the best of intentions, where we either do illegal conduct or we do some injuries to others, even though we didn't mean it. And these kind of fall into the two categories. The one of greatest concern is criminal law liability. You know, if it's illegal to possess certain forms of electronic contraband, you can't do it for research purposes absent very special circumstances, like you were acting under the aegis of a law enforcement agency. If you cannot access a machine without authorization, it may be illegal to do that for research. This comes up in the area of cyber self-defense or active cyber response. When is it legal to intercept electronic communications? And even the idea, what does, quote, electronic communications mean within the statutory regime for information protections in both the United States as well as the rest of the world? It's worth considering that there is also potential for civil law liability. And this is a wide open legal regime that under American common law and accompanying statutes is evolving probably even as we speak. So it's hard to say, what do I need to do to be sure that my research and practice doesn't hurt others or run afoul of the law? And sometimes that can be there's no clear answer. Just real quick, you can see this blows up quickly with issues of the Fourth Amendment where you have a state action. What constitutes private citizen trespass? Say when you're a private company's IT security folks decide to go back after someone they think might be attacking them. What is the interception of data? What are the laws that apply? And it is very messy and it goes on and on. So, Jared, these are some concerns that we've just sort of circulated from the community. What are some issues people have raised with us?
As far as the CWE project?
Yes, or just hear these concerns.
Okay, so one of the main issues is who's the reporting authority for cybersecurity violation. And there are reports for reporting certain issues in cybercrime, such as Homeland Security has their own task force, the IC3, or ICAC, Internet Crimes Against Children. A lot of the public doesn't know that. So a lot of the issue, especially with research as well, is underreporting in cybercrime. We don't have accurate statistics on what's going on because a lot of it we don't know about. So the issues in education and training, right now we're just now starting to develop how to assess people's skills in cybersecurity training. There's a reference to the February CIA forum by Levi and Carlton for the Cybersecurity Skills Index. And this is something that as a cybersecurity community, we're trying to build and implement because the world of technology is such a broad environment and a very complicated one at that. So figuring out people's strengths and weaknesses, especially within, say, police departments and their cybercrimes task force. Do they know to the full extent how operating systems work on iPhones versus Androids? There's different niches in the world of technology, and figuring out how to train for that is an issue. How to document the evidence and build these cases, Losavio.
Well, yeah, and as you see, these are the issues that begin to grow as you start to integrate cybersecurity into a public safety, public security regime. Because you're not just looking at locking yourself down the way we might have done in the mid-19th century if you were a bank. You're looking at other systems for protection that can enhance what you were trying to do. One thing in this list of questions people sent in was the notion of education. And I think one of the constant issues that comes up is the security vulnerability by an end user of a system. And we generally don't do a very good job of training people how to safely use their devices. As Adrian said, we teach our children out of the box. You look both ways before you cross the street. We don't do that when it comes to, what's that attachment in that email? Jared.
This relates back to earlier when we were talking about general issues, avoiding an inside view of cybersecurity and cybercrime, essentially giving the tips and the techniques that the experts know and releasing them to the general public. Obviously, this won't make every mom and dad a cybersecurity expert, but essentially giving them the basic needs of cybersecurity so that they can teach their kids out of the box about clicking certain links, apps to be used on their phones, things like that.
All right, another question that comes up is jurisdiction. And in this case, who does it belong to and who's responsible for checking to see that a cybercrime has been committed, or who's responsible for prosecuting it? There are many different legal frameworks that are involved at different levels at the state and federal level. And there are always gray areas, of course, between countries and between different legal frameworks of how you can prosecute cybercrime. What are legal methods that you can use to either deter or catch cybercrime in progress? Honeypots is some of you may be familiar with. These are active sites that are portraying to be targets of value, and cyber criminals will often pop in there and they'll be caught because they are specifically designed to trap people that may be trying to commit cybercrime. Is it legal to perform a counterattack? Is a particular question that is also in a gray area. In other words, what is your recourse if you are being attacked? What can you do back against those attackers beyond just defensive measures? There are questions of encryption. The DMCA has always stated that the Digital Millennium Copyright Act was one of these hotly debated acts where it was made illegal to decrypt or to open up the intellectual property protection mechanism that was either in an audio video stream or protecting software. How does that relate to needing to do that for sake of defense and privacy? Questions about mutual legal assistance treaties, or if there are conventions on cybercrime. HIPAA is another particularly sensitive subject area. What can you use in terms of data, especially in electronic medical records and health industry, while still maintaining HIPAA compliance? Juvenile confidentiality laws, which of course affect how content might either protect or not protect identities of minors. And then the Privacy Act of 1974. All are areas that complicate the picture of how we understand cybersecurity.
So, all right, so we'd like to hear from you if you don't be shy, because, I'm very shy. That's why I like this medium. It's very intimate, but not. What are the concerns that you do in your cybersecurity research and practice that you might like to have us discuss? And in fact, let me correct that. What might you hypothesize happens in other people's cybersecurity research and practice? None of us wants to end up before a grand jury. And again, people can be acting with the best of intentions. You just want to be careful, especially now that you've got, to be concerned about civil liability. So who has some thoughts? What have you got?
I don't have Jeopardy music right now, so.
Dun, 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 dun. All right, Adrian, what would be your biggest worries or concerns? Wait, what do we got?
Many SMBs are unaware of basic security concepts. Is there any research on best methods for reaching them?
Small to medium businesses, I'm guessing, yes. Wow.
This is what I'll jump in on.
That's huge.
This is kind of the concept of digital hygiene as something that you can't force. Well, okay, Microsoft forces and Apple to a degree forces as well security practices and industry best practices on software. But the problem with that is that there's no visibility. You know that your computer is doing updates, it's running a virus scanner, it's taking care of things in the background that are trying to prevent attacks either passively or actively. The problem is that nobody knows what's going on there, and that's where a comprehensive cybersecurity education needs to be a cultural phenomenon. Now, it's all fine and good for me to say it has to be a cultural phenomenon, but if there's no way to do it, that becomes problematic. I have had plenty of experience consulting here in the Louisville area for businesses, and I'm very, very much aware that there is very little information penetration about what companies need to do to protect themselves and their assets. That's where I believe both in making this part of just a standard secondary education policy where people that are exposed to bigger concepts in college environments are going to have to be exposed to some of the basic tenets of digital hygiene and information security. I think the question is, how do we develop a comprehensive cybersecurity education when it's not part of the Common Core and we don't have teachers? That's the chicken or the egg problem.
Existential question.
That's the chicken or the egg problem. We know that at the university level, we are implementing these kinds of things. However, the CAE community is perhaps one of the best places to have this kind of a dialogue and to bring together different viewpoints on how to integrate cybersecurity education. I personally try to implement it into my coursework, even if it's not my network security class. But it's just one of those things where eventually it has to be ingrained into the culture. And yes, it is not as easy as looking both ways when you're crossing the road. There are so many issues that get into the way of having a good, stable cybersecurity digital hygiene, if you will. And perhaps this is a good a discussion question for everybody that I'm sure people would be happy to have following the presentation.
Sure. I mean, if any of you have thoughts on this or have programs in place, let us know. We've actually tried to do it here at our university. And after initially getting a lot of positive feedback, our IT department just stopped returning our emails. I am not sure why there is such hesitancy to do this. Anecdotally, some people say, well, that's not really a learning subject. Although, we spend who knows how many hours trying to practice our cursive. But there is some block. In fact, in 2000, at the beginning of the presidency of the second George Bush, they released a major cybersecurity study which identified two major vulnerabilities. It's the small and medium businesses that Ron has asked about, and the individual small home users. And this has been brought up several times over the past 18 years, saying, what are we going to do about this? But consistent programs to try and address them are minimal. This department here had a community engagement obligation for students where they had to go out and just do basic work with people. And a number of them did their projects in small businesses, in churches, in schools, and they just, they were stunned at how wide open the systems were. And I think, as maybe Ron's question anticipates, who's got the money to come in and have somebody help show you how to lock this down? How do you even know enough to get somebody who knows what to do? Jared, you've been working trying to see if we could even get local TV stations interested in doing cybersecurity short pieces. What's been the response you found?
Right. So unless an interesting crime is happening, they haven't been too interested. It's just a topic that's, even though we've sort of been in this technology phase for a long time now, it's still very foreign to people. As soon as you mention something about encryption to someone, at least to the general public or a police officer who doesn't know about cybersecurity, it's a daunting task. Encryption is, for someone who doesn't know, it can sound daunting itself. So trying to convey especially through the media, these stories about the program that we're teaching and general cybersecurity tips, they're interested, but it's not as interesting as the cybercrime taking place itself.
So, and I think as the comment here is that there are some excellent potential programs out there. It's getting people engaged in it to see it as something which is a priority?
Right. So when we were first doing the CWE project,
oh, yes.
One of our tasks.
Just before we begin, one thing we found when we started doing this with law enforcement, people were saying, oh, you might get 10 or maybe 20 people interested in this training program on cybersecurity. What did you find, Jared?
So we weren't sure exactly what the interest would be, but that, especially in law enforcement, people are very interested. Our numbers exploded, and we have well over, in this current project, can I say the numbers? Sure. So in this current project, we have about 20 U of L students, but police officers from a plethora of different roles, canine, narco, bunch of different roles from 18 different states. We have over 137 officers. We were only expecting maybe to get 30. And then after the program started, we had an additional 200 ask about the project or the course continuing next year. So there is interest among certain people, but in speaking with these officers, getting these officers to talk to the public, it's a bit harder because in police, they have a natural duty in security itself. It's just changing environments from the physical world to the digital world. Now, getting that information to the public, we've seen that they're generally not concerned unless they've been a victim. Trying to get them involved in solid preventative measures rather than reactionary measures is sort of an issue that we're having. But as far as, who's this, Rob? Who made that comment? Yeah, Ron. There are a lot of open source material. So when we were building this program, we were trying to look at open source material to help, aid us build our course modules. And there is so many, Cybrary is a key one. They have well over, 200 different lessons and everything, cybersecurity, that are completely free unless you want to pay for certification and things like that. So, Ron is absolutely correct. There are open source materials out there that that people of all levels can take advantage of. So yes, we have the issue that maybe we were lacking qualified teachers and the money to pay those teachers if we have them. However, there are open source materials that, again, people of all levels can take advantage of.
There's one aspect of this, of course, is how does popular media approach this? And Adrian has sort of become a go-to guy. Whenever there's some big blow up in computer security, they come out with the cameras and interview him. How effective is that, Adrian, or is it just episodic?
Yeah, it's very episodic because as is anything in our cultural consciousness, whether it be political or news stories or you name it, people always get worried or outraged by something that happens in the media, and then they forget about it after a while. So there are many resources out there, especially some that have just been posted here. But news media coverage is always spotty at best, is what I can say. It does not have the desired outcome that fraud is reduced and that people are less likely to be victimized. The only things that seem to be having, significant impacts there are industries push changes in regulations that make security sort of part of the tool set that we already have available, whether we know it or not. The only problem there is that, of course, that does not require the human beings present to know it's there and know what to do about it. Think about it, stability control is now mandated on vehicles. So that means that you're a lot less likely to have a loss of control accident with your car because it's monitoring your yaw rate relative to your intended steering angle. And so your car will automatically anticipate and perform independent wheel braking to try to get you back on course. But that still cannot defy the laws of physics. And if the person doesn't know that, perhaps they've encountered the system before and didn't know that they are operating outside the normal bounds of driving, you can still find yourself in plenty of trouble, even if those systems are there. And so you can't idiot-proof everything, not to use that disparagingly, but you cannot make systems foolproof.
And so education in many multi-layers is really the only answer that I can think of. You have to have the basics in preschool all the way up through your college and graduate education.
Excellent. Thank you, Adrian. And thank you very much, Ron, and other contributors.
We have a question on network traffic and
Marcella.
Yeah. Public Wi-Fi hotspots for research purposes. Okay, I'm not going to go into the legal ramifications of that because that's not my jurisdiction. However, and I'll ask that to Michael here in a moment. Just off of the technical standpoint, of course, that is something that is doable. How much of that you're going to find is useful information is kind of up for debate because if you're sniffing in on an encrypted session, that may or may not produce any usable data. Michael, what are the legal ramifications of performing? I mean, that's really, it's pen testing is what that is, and it's not an authorized action as far as I can tell.
Unfortunately not. It's to the extent you're intercepting any content information that is protected. And since all the transactions are going to probably be under some, WEP or WPA, you're now circumventing an access control that probably runs into violations regarding 18 United States Code 2510 on intercepting electronic communications. And you do not want to do that. Even if your purpose is not malicious, but for research, it can create problems. Now that's for content information. Now, if you're looking at, say, metadata or transactional stuff, things get a little blurrier. And that really would be something I would want to have checked out with people up the line, if only so they'll agree to defend you if problems result. We have had, I hate to say this, we've had some really well-meaning students who have done certain projects to try and warn people about their lack of security on their systems. But for them, in order to do this, they had to engage in information interception and accessing those people's systems. That is not proper. That's not legal. Nothing's going to much come of it, I would generally think, unless you just irritate the wrong person.
I'm going to cap this off with two things. So Marcel says it's not pen testing. I respectfully partially disagree with that just because pen testing is not just intrusion, it is also data gathering. And so listening is part of penetration testing, in my mind at least. If you boot up Kali Linux CD, most of the tools there, or many of the tools there, are for intercepting information or at least gathering information, listening. But I get why not pen testing is a valid point, because you're not actually seeing if you can break in, you're just trying to passively capture traffic. At the same time, if I go to a business and I insert a network tap and start dumping their traffic, they're not going to like that either. So it's kind of, I think, a gray zone there. The other thing I will say is that so a company that does a research contract with us, their product online was recently targeted by one of the departments that does, it's an NSA department, no, it's a Pentagon department that does hack the Pentagon. It's a group that they employ. It's the Digital Services Directorate, something like that. They hit one of our sites mistakenly, thinking that it was a government site, which it was not, and gave us a report and started fishing through to see who the point of contact was. Now, this was all public domain information, but it did require some work. And the owner of the company was not terribly pleased by this because he saw it as an invasion of privacy, which it rightly was. So, it was some, a little bit of pen testing just for beneficial purposes to let people know, hey, you could have vulnerability, whether it actually was one or not was not particularly relevant. It was still an attack from all.
Right. Well, and this partly, yeah, and this highlights the fact that the controlling statutes are all decades old. Essentially, the Wiretap Act, Electronic Communications Privacy Act Part 1, 18 U.S. Code 2510 et sec controls this. And this came out back in the 70s. What they prohibit is the interception of electronic communications. And by that they mean, quote, any transfer of signs, signals, writing, images, sounds, data, or intelligence of any nature, transmitted in whole or in part by wire, radio, electromagnetic, photoelectronic, or photo-optical system that affects interstate or foreign commerce. So they're reaching quite broadly into this area. And they're not, and this was well before you could do research in this area. I mean, everybody essentially had to hook up a wiretap to a system, but these still apply and they are still a controlling law. The Wiretap Act is very serious. It's a felony violation plus civil damages. So it's any sort of research in this area that you do outside of a lab has to be done, I would say, clearly under the advice of legal counsel. And I would say generally, you don't want to do it unless it's truly communications in the clear. It's bad stuff. But look at the flip side of that. How do you then? It's sort of like what happened when they made powerful encryption problematic to work with in the United States. Well, then how do you do research when you have these limitations on your ability to study these problems? The DMCA really put some legal technical hurdles in the way of doing encryption research, which I think ultimately hurt the people that put that statute in place because it meant they couldn't get a broad crowdsourced way of examining the robustness of the encryption so they could secure it. And essentially it meant people who were more willing to violate the law could study these problems, find solutions, and then do what they wanted with them. I know that's a long way to go into this, but that's one reason why we're so concerned about this, because it is such a morass. And by the way, everybody, Marcella has cited the particular statute in play, which might be worth reading, when you don't, you're just not sleepy.
Shall we?
Yeah, let's go.
All right, we're gonna skip past this slide.
And by the way, this is just to show, Adrian will talk about this. Here's some things you might not expect. What is contraband in the electronic environment?
Right, so of course, child pornography is an obvious one. And it has an interesting way of being caught and reported. Some of you guys are familiar with file hashes, which are digital signatures of the files and how they're used in peer-to-peer networks to identify sharers of the content. In addition to, examining sites with backdoor entrances and where pedophile rings typically tend to operate. So, of course, possession of child pornography or the distribution or the receipt of it are all illegal. I guess obscene materials has some statutes in as far as networking goes. Distribution of copyrighted content. This is an obvious one where we see the RIAA and MPAA, the Recording Industry Association and the Motion Picture Industry Associations of America, hiring companies that will actually go and try to identify the sharing of illegal material. This has been an endemic problem until, interestingly enough, it has been an endemic problem until affordable and easily accessible content distribution schemes such as subscription services became available. It's kind of funny that the crime in this case was indicating a need for better access. It was still a crime, and I've had plenty of exposure to this from individuals at my own university where I went to school, being involved in this and being sued and settling out of court. The distribution of trade secret information is considered contraband. Any circumvention of copyright protection, thanks to the DMCA. There are exceptions, of course, and one of the exceptions, I believe, is audio CD ripping and DVD ripping for your personal use. That requires a DCSS algorithm that was developed billions of years ago when DVDs were launched and supposedly copy protected. And then possession of access devices such as passwords, RSA keys, so on and so forth, that are not yours would qualify.
If they're intent to commit a crime with them, it's if you're trying to do illegal stuff. Yeah.
Right. Then we also have to understand unauthorized actions. Worldwide, that would mean unauthorized access to computers, such as cracking a password, using a vulnerability, or exceeding access control levels. So using a privileged escalation vulnerability to get administrative access to a system to which you do not have access to or should not have access to. Interception of data, and I think that goes to Marcel's question of sniffing traffic on a Wi-Fi hotspot. That is data that is not yours, I think, ultimately. And so I think if you were grant funded by a 3-letter organization, they would probably not be very happy if you were using that as research data. That's my best guess. I mean, of course, that's not a, I don't know, it depends on, I guess, the organization, but as far as I know, would not be considered necessarily ethical. Interference with data, this is addressing the CIA triad of confidentiality, integrity, availability. So messing around with the availability of data and unauthorized interference with a system that is making perhaps the data available. Misuse of devices, this includes passwords and things like that.
And just for quick reference, as Marcella noted earlier, 2510 plays a role here, the Wiretap Act. When you're looking at stored electronic communications, 2701 plays a role. When you're looking at metadata, then you got to look at the pin register, trap and trace statutes, which is 3121 at SEC. And again, notice just by the nature of these terms, a pin register, you can see the age of these technologies going back to the use of telephony as a major investigative tool for law enforcement.
Ed has asked, what if we are capturing packets in a Wi-Fi location on open Wi-Fi? I believe that question, we may have partly discussed it, but the thing is, some of those packets are going to be encrypted, which means there was an intent to obfuscate or to hide that information to preserve confidentiality, which means that I would be willing to guess that most people on a network would not consent to having their data taken. Again, I will argue that it is almost the same thing as going up to a company and disconnecting their Ethernet cable to their service provider and installing a tap. I mean, you'd have to break in and access it physically, and I get that that's different, but you're still circumventing the point of public Wi-Fi. Now, that's a very weird case, because if people are talking in a crowded room and you're intercepting their communications, how is that different than open Wi-Fi networks? I think it's less obvious there.
All right, we'll make a brief version into the evolution of privacy law as from the common law to today, and that's really the issue that Adrian has raised. Do you have the buzz phrase is a reasonable expectation of privacy generally, and that's used to define state action investigating you limited by the 4th Amendment. But it also has a general applicability to what's proper conduct by individuals. These statutes are efforts to reflect what is considered a reasonable expectation of privacy. Now, 2510 talks about it's okay in certain circumstances to intercept publicly accessible information. So if somebody is just using like a walkie-talkie or running out, I would say possibly, see your lawyer, they're doing Wi-Fi packet interception where there is absolutely no encryption or protection that's, at all, well, that's publicly accessible. That's not a problem. It would be unreasonable for us to think these people are expecting privacy, even if they may have a subjective expectation of privacy, because they're just broadcasting to the world. But once they put some kind of a lock on it, like even if it's something as as crackable as web, then that changes the equation, and that changes the liability you might face for interception and decryption of those packets. If you look at the issue of the people talking in a restaurant, an open room, if they are talking quietly and you can't hear them, but you decide you want to use a sound gun to pick up what they're saying, the use of that augmented technology is illegal.
So that could apply to an open wireless network and picking up packets. And I think that may be where that sits. I personally don't know the legal ramifications of it. I know that there would be some fault on the operator for not having, perhaps an industry standard best practice for having wireless encryption at least running, but that's a good question.
And Ed notes, by the way, a VPN, that's a perfect good example, Ed. If they do use a VPN and you're intercepting that through some kind of man-in-the-middle method, then you are violating that expectation. By the way, we'd like to give a shout out to Andrew Wright, who has also joined us, who's one of our co-researchers on the police project. So thank you very much, Ed and Andrew.
So perhaps we should we talk about this framework, or should we move on, because we're far lacking on time?
Just real quick, actually, this framework, maybe we're probably getting the end of the time, but the other big daddy to be concerned about in statutory structure is the notion of what is authorized access versus unauthorized access. Someone who is under that common parlance of a, quote, hacker, we're looking at somebody who is gaining unauthorized access to a system and getting all manner of things, services off the device, credit card numbers, personal information, trade secrets, all of these things. It is analogous to the doctrine of trespass in common law. You are invading somebody's area to which you do not have a right. It's part of this evolving notion of that area of privacy. Well, what precisely, though, constitutes unauthorized access, especially when you've got the internet that's really set out to say, hey, let's all share our information. Going back to DARPA's implementation, which is a group of research scientists all looking to share their information. So when you do your research, you need to be careful about what you are doing, and especially if you're looking at things like hackback or positive cyber defense, active cyber defense mechanisms.
Should we just skip to the authorized section, or?
Sure. Anyway, just this particular table, which you can then look at later, sort of breaks out the basic ideas that are set out in the European Council's Convention on Cybercrime as just the general taxonomy of improper activity. Now, just to confirm everything you ever thought about lawyers being unable to give you a straight answer. Authorized access, with the advent of these devices, and because it was not the physical trespass we knew at common law, courts kind of really wrestled with how do we deal with this kind of misconduct. So finally, they began to say, no, we're going to make our own statutes that ban this kind of conduct and make it clear that there are criminal and civil prohibitions here. The government of the United States, under 18 U.S.C. 1030, said, okay, no unauthorized access. They did not define what authorized access meant, so that you get sort of curious situations, you kind of grapple, what does it mean? In fact, and this actually turned out to be fairly effective. One federal court was trying to deal with this, just went to the Merriam-Webster Collegiate Dictionary, always a comfort to me. And they simply said, hey, it's where you are exercising the ability to make use of something. And that, okay, that's reasonable, but how far then do you go within the facts of this computing technology to toll that responsibility, to say that you have access to number one, and then we get to the question, what is your authority to do so? And you might have explicit authorization, or perhaps you have implicit authorization. But those are questions you have to ask. And courts have not necessarily been very open to arguments regarding implicit authorization. In fact, as this one court noted, the Computer Fraud and Abuse Act, 18 U.S.C. 1030, is designed to impose limits on access and control access to that which is held by someone else. Now this came in sort of the somewhat earlier days of the World Wide Web, but as you can see, maybe you can put explicit statements on your website that can then limit access. Or even if there's not an access statement, how do you know that you're supposed to be there? And this sometimes comes up because, as we've had happen here, people will put up internal documents not realizing that they're web accessible. And naturally, the really good search engines find them out, and people are embarrassed all over. So this doesn't leave a whole lot of guidance for you. And we would suggest you have to be careful. Look at the technical interaction of your devices, what you are doing. So then you can then make the case one way or another, so that it doesn't put you at risk as a researcher or as an investigator. Here, okay, I'll leave this to Adrian, but we're just looking at sort of basic functions, which are authorized and which are not. Adrian, what would you say here?
Right. So I might actually disagree with some of the points here, but
fine.
So a ping being it could fall under the category of unauthorized access, but pings are also used for diagnostic purposes and are not necessarily malicious in intent. I regularly ping Google DNS or one of those other services to ensure that my network connection is up for whatever reason. So pings don't always have to follow as an unauthorized computer access. Oh, it says no there. Okay, I agree with you, Michael. That is not an unauthorized access to computer because it does access a machine, but if you have ping open, typically it is designed such that you will respond to a ping request. A query, so would that fall under unauthorized access? If the machine is built to respond to the query, then that is not going to be a violation of access.
But notice we've qualified it probably, so don't sue us.
Right. Now, on the other hand, if I can figure out that your site is vulnerable to SQL injection and I issue a query that is not designed to be run on that, that's an inappropriate access. A GET request, this one also kind of depends. If it's a web GET request, those are normal. But if you have circumvented access control and you're withdrawing data that should not be accessible to you, then that would of course be a violation.
Ouch! Troy just pinged us. I'm injured.
So no, a ping is definitely not a crime as far as I can tell. It can be disabled, but that doesn't mean that it's a crime. So authorized access or right is assumed in the use of services by placing machine on the network without blocking the services in some way. Each of the services makes a greater demand on the target machine for the responses and data. And there's a case that is used on the old Gnutella protocol. Gnutella was used for file sharing. Here's an interesting example. So a research tool could be set to harvest data on query traffic. So these are the searches that are made for files on the Gnutella network or this particular P2P network. It harvests the data by placing machine on the network as a leaf node that transmits to an ultra peer, which is a peer that coordinates a lot of these requests and sort of acts as an ad hoc router. It sends it a file with data that asserts that it can respond to all queries that are sent. So
Oh, by the way, Ed just made a good point comparing passive to as opposed to active reconnaissance.
Sure, passive versus active in this case being if you're, I guess, do you want to define that as exceeding access control or just seeing if I can, that's a good question, Michael. What would you think of this? If I enter an apostrophe on a website to see if it spits out an error and lets me know that the site is possibly vulnerable to SQL injection, is that active or passive? Because have I exceeded the site? Have I made it do something it's not supposed to? I've just made it give me an error message, right?
This is really the Full Employment Act for the lawyers. There have been some early cases from the days of dial-up modems where that might be considered just minimal enough that we'll let it go by. But if you did it several times, so in other words, I guess as Ed notes, you're clearly engaging in an action that is abnormal and probably designed to produce a bad outcome, at least for the website controller, then we could come after you. That your actions thus constitute an unauthorized and improper access or attempt to access the system. Jared, you want to talk about how we're not really getting into criminal law and the principles that, when do you have enough evidence to sustain that somebody did something wrong here? Especially when they get braced by 2 FBI agents and don't crack.
So Marcel, by the way, has said that active is a good way of saying you're poking at a system, and that's where I agree.
Good. Yeah, that's
I agree because if you're putting in that. Now, what if you put an apostrophe, to test for SQL injection? What if you did that by mistake?
That would be the issue of where, by doing it just that one time, we like Latin so much, de minimis, so that because you can't really tell, was it an intentional overt act of an attempted crime, or was it just some casual mistake? Yeah. I mean, I would hope, I don't, but what if you set up a script that goes around and throws commas into, every website?
You purposely developed it.
Well, anyway, I think we're we've kind of argued past the P2P experiment tool. The point of that that particular example was that is the transmission of the routing table, which establishes it as a source of data for file queries. Is that sufficient to constitute access? And if it is access, is it authorized? The P2P network is doing what it's supposed to do, and you're giving it valid information, but that, I guess, might fall under the intent side of things. Michael, shall we switch to remediation?
Yes.
Because we are, again, out of time.
We're running out of time. Yeah, I mean, well, folks, it's not really hopeless, but Orrin Kerr, who has been writing on these subjects for quite a while, he thinks we need to revisit all of the statutes as they relate to these violations, to at least structure them so that it's clearer for everyone as to what's proper and what's not. This would perhaps require clear definitions as to what constitutes the conduct in which you engage and what's improper. DMCA is interesting. It actually has a research exemption, but it is so, the requirements to invoke it almost require you go to university counsel to help work out the letter you need to send to the owner of the encryption technology or user thereof to do so. So whenever you start getting into statutes and statutory amendment, it's important that you have political representation who understands how important this work is for commerce and research. It's worth the effort, but it really would require a great deal of extra work. Now, you could, and this comes down to what you all might think is appropriate. Do you try and match it up to aspects of the technology? Now that would make an issue perhaps for future evolution of the technology, but at least it would bring it up to date with the way we currently are engaged in this environment. The issue of entrapment in an online environment has come up because, you know, what is a honeypot? Well, you know, it's out there, we're letting people come. Does that constitute entrapment? Which is a defense to criminal activity. And if you are looking to deter conduct, you don't want people getting off on a defense. And entrapment is not just a technical defense. It's saying the police were acting in a really bad way trying to encourage people to commit crimes. And a police department never wants that as a reputation. What constitutes, I mean, you've raised some really good questions about what constitutes the illegal interception of communications, especially when the air around us is now full of this in ways that were never anticipated, at least at the time these statutes were initially implemented. Privacy technologies and expectations are really underdeveloped in the United States, especially as compared to the European Union. Do we need to have safe harbors for researchers? Because as Marcella mentioned, you know, we're not doing this maliciously. We need to know if there are issues here. And if we can't research them, it's going to be much harder to provide protections for them. And there have been, as I think all have heard, there have been some remarkable cases in the past 24 months. Apple uses its own encryption protection regime for iPhones, so that because the Department of Justice wanted access to iPhone information, first in a sort of run-of-the-mill drug case, and then thereafter in the San Bernardino mass murder terrorist incident, it used a 1789 statute, the All Writs Act, to try and force Apple to develop a decryption technology that it did not have for its phones. Now, in the run-of-the-mill drug case, which was the first case up in a New York federal court, the judge said, I don't think you can do this. I don't think you can force these people to develop these cracking technologies. But in the California federal case, with a much more sympathetic situation, here you've got the mass murder of people by terrorists. The judge was more sympathetic and said, yeah, you've got to go do this for them. I mean, that's just goes against a whole lot of traditions in the United States regarding what you can make people do. And fortunately, Department of Justice ended up avoiding the problem by hiring an Israeli company to provide the crack and avoid this. But you can just see how these issues are just moving along faster than we can go. Adrian, Jared, where are we going to go with this? What's going to happen to us? Any thoughts, worries? You got to evolve.
We did get a we did get a couple comments. Let's see if we can scroll up here. In this case, recommendation would require politicians, court systems, law enforcement, attorneys to understand cybersecurity. Yeah, that's
don't be cynical.
So that's a chicken or the egg problem. How are electric vehicles going to be ubiquitous to the country? It would require electric utility grids, private companies, and all sorts of regulators and car manufacturers to adopt universal standards that allow those vehicles to take place. But there is a financial incentive to make that happen, and that is if the price of oil starts spiking or we start getting sick of internal combustion, there's a financial incentive to make that happen. And I would argue that there's the same reason for cybersecurity awareness and education and policy to be made. There's a growing every year. We're talking of hundreds of billions of dollars, and there was a SANS Institute report on this, I believe, and from Symantec, hundreds of billions of dollars involved in malware in terms of both lost productivity, lost trade secrets, actual financial loss due to ransomware, you name it, there is a financial incentive. And once I think the pain gets strong enough, and unfortunately, as a species, we sometimes wait till the pain gets bad enough before we do something about things. I think once the pain gets strong enough, some of that will be a pretty strong motivator to address these policies head on. But as we are a reactive species, we wait until it hurts too much to do something about it, and then it'll get done. Yeah. So. All of these things, I think ultimately there will be a financial pressure to address it. I wish that the financial pressure were already bad enough now. And I mean, if you look at the number of companies in the Fortune 500 that are security companies that are supposed to be doing things like this, that are supposed to be helping us on these grounds, there is definitely a direction there. But how that gets into policy, I mean, to be quite frank, our legislators have little or no idea of what they're doing when it comes to policy for digital systems. There is not much, as far as I can see, expert advice in the process. There's some, but everything comes completely too late there. So that's going to have to play a pretty fast game of catch up to meet up to it. But I do believe that, at least on the business side, things are becoming a little clearer. Also, productization matters. If you have a security product and security appliances that are very difficult to use and not plug and play, nobody's going to buy them. But if you're Cisco and you're making something that is plug and play, and you add a simple low-cost monthly service fee to it, I mean, that can go a long way to improving things. I mean, I think the financial incentive is the biggest one here.
Yes, and I think, as Troy mentioned, NSA seems to appreciate the scope of this problem as well as the FBI. And oddly enough, in the first year of President Obama's administration, they put out a major report on the need to revision how we do cybersecurity. And but the money didn't start coming until last year. And I think it's being able to put money into a plethora of research projects and development and training projects, and then seeing, are we having a beneficial result, is, I think, maybe a good way to approach this. We just put this up because it just we were trying to be current on this stuff, and all of you work with this technology, so you're all engineers, and engineers are great people. And yet, here's a case, in some ways it highlights misunderstanding of information and the systems and what they do. In this case, this father of, I think, 2 or 3 kids, engineer, happened to have the same name as this guy who was dealing heroin. Well, what's the necessary standard for attribution and authentication? Apparently somebody in the police department took the name and just ran it through a database, and he's a righteous citizen, his name pops up, and so they stop him and they arrest him and they put him in jail. And the next day they made him actually clean. He had to scrub the floor of his holding cell, because that's what they do. And then they finally got it straightened out and let him go. But the misunderstandings that are inherent with even database technologies, much less everything else, just creates these risks and policies. I think you all's concerns about how much our political leaders understand, I think, is well taken. But that, I think, puts an obligation back on us to say, Mr. Congressman, Mr. Senator, wait a minute. We think you need to look at all of these issues if we're going to have a complete and global regime to protect everybody. Because going back to our earlier slides, how this is really becoming a major issue of public safety is something we can't ignore. And we want to, because it's a really tough issue. but you all unfortunately are on the bleeding edge of protecting the American public. And as Adrian and Jared say, you know, do we want to prevent something bad from happening before it happens, or only respond after bad things begin to occur? Jared, what would you want to close this out?
I'd say that's a pretty obvious answer. We would like to take preventative measures, but because, especially to, as Adrian pointed out, to legislators, we're not really sure what's going on. So right now we're only in a position to react. We're still learning. And back in December, in the Senate, they had produced a bill, S1241. It's supposed to bolster anti-money laundering laws, and they're trying to include digital currencies in that. And it's, again, it's very late in the making, but policy is viewing the implications, and we're trying to combat the issues that have come up with cybersecurity. So it is in the making, but, you know, as people have pointed out already, it's long overdue. And this is why, you know, we have things like the CWE project to try to teach them the basics and just a little bit more. We believe that cybersecurity is a complete team effort. So yes, we may push towards policy, which would be great, but it still falls on the end user, as we touched on before. The end user is responsible for securing their devices and their information, and getting them that information, or getting the knowledge out there for the general public to do that is key.
All right. So I guess we've run over the limit. We do apologize. But first we want to thank Anastasia Webster, who has been our Zoom master for this, as well as, of course, the CAE community and our colleagues who are supporting it at NSA and DHS. Would you like to sign off for us now, Adrian?
Yeah, so this is Adrian Lauf again. Thank you all for coming, and thank you for making this a dialogue. Really, cybersecurity is a conversation. All its legal and technical implications are a conversation. If we keep having these conversations, they become a part of our culture. And so we really appreciate everybody's comments. I think it makes it way better than just three people trying to talk at people. So thank you for making this a conversation. Wish we could actually hear everybody, but that would make it very difficult to actually make it work logistically. So we appreciate all the comments, and thank you for joining us today.
All right, thank you all.
Thank you.
Thank you both for hosting this meeting, and thanks to everyone that attended. So to watch today's recording, you can go to caecommunity.org under CAE Forum Resources. If you are interested in participating as a speaker, please contact CAE Forum at caecommunity.org. Thank you.